Good morning, ladies and gentlemen. Good morning. My name is Piet Leroux. I'm the Chief Executive of Sakeliga. Welcome to this briefing on the matters relating to Northwest, the cases of municipal failure there, and upcoming court cases and litigation that Sakeliga is undertaking to set precedents to change the course of municipal failure and what business communities can do across the country. Welcome especially to members of the media to this briefing, as well as our partners in Northwest, people who've been supporting and been instrumental in making the litigation a success so far, and the other activities, Agri Northwest and others in Northwest, and as well to any supporters and members of the public who are attending this briefing out of interest, because what happens in Northwest is relevant to what happens with municipal failure across the country. The purpose of today is to give you a briefing about the court cases on 5 and 6 October in the High Court in Mahikeng. Two important cases will be heard. These cases have been building for more than 2 years. Sakeliga, in collaboration with partners in Lichtenburg, Ditsobotla municipality and others around there. And the case and the judgment will be very impactful for municipal failure across the country and what can be done about it. I will start by giving you a brief overview of the strategy that we follow, why we've picked the cases of Ditsobotla, of Lichtenburg and the surrounding area in Northwest, why that makes for a good court case. And then I will hand over to my colleague Tiaan Alberts, who is with me in the studio today. Tiaan coordinates all our legal matters at Sakeliga internally, and Tiaan is well adept to and will be able to give you a timeline of what has happened over the course of the past 2 years, what successes we've booked so far with the litigation, and also what other alternatives the community is already building there in Northwest. We'll close then with time for questions. If you have, please, whether you're watching on Twitter, YouTube, Facebook, send those questions right there in the comment section. Our team will pick it up. It'll appear on my screen and we'll handle it at the end, subject, of course, to time constraints. All right, Tiaan, can we bring up that first slide that we have there? So, ladies and gentlemen, Sakeliga is a business organization, and it's important. I'd just like to explain what strategy we are following here. We're a simple to understand organization, and the purpose of this of Sakeliga is to create a favorable environment for business in the public interest. To do that in South Africa, it means that we need to build scalable solutions to state failure. It's a little bit different from what business chambers all over the world might do, because in South Africa, let's say two very important things have come together. The first is failing a state capacity. So even where there's a willingness to change something, there is not capacity at state level. And we've seen this with cases of municipal failure, but many other problems across South Africa. So there's an inability to implement reform, lack of capacity, one could say. But then secondly, it's even where there could be capacity, there isn't always the other element that is required, which is the will to do something and the conviction on what is the right thing to do. And so that is why so many distressed municipalities across the country and so many towns are in such a bad shape. It's because there is neither the will nor the ability, apparently, to intervene and pull things together. Now, in that context, it's no use lobbying harder. And it's no use putting all your money behind a voting strategy. These towns are failing right now, and it's harmful for people. It's a harmful business environment, and that, of course, has consequences. And one might be mistaken, and I've seen this before, where people say, well, it's some small town in some province somewhere. The problem with just looking at municipal failure in an isolated way is that you're going to miss the seeing and misunderstanding what that means for society in general in South Africa today. If we allow municipalities to fail in rural areas and we don't stop the spread of that, then what we will see is an exodus from these local municipalities to district towns, to towns that have barely coped with the pressures of service delivery and state failure themselves. And once these exodus takes place, they of course will not stop at the district towns and the larger centers in rural areas, but they will spread. And eventually the pressures that couldn't be dealt with at a local level will reach metropolitan areas, and then areas like Gauteng, already seeing some of that, will really buckle under the pressure. And just imagine Johannesburg being unable to cope with its current services to its current residents. Imagine a state of failure expanding across the provinces in South Africa, and then how big cities and metropolitan areas would cope with that. So it's very important, not only for local towns and local economies, to stabilize and turn around the state failure and the collapse there. From that perspective, it's important for every one of us, whether we live there or not. Tian, I don't see our PowerPoint on the screen. Can we just bring up that there? Let's say if the team can bring that up. I'm not seeing it. Okay, that's fine. I'm going to look it over here. So the key thing there is the problem. The problem is state failure, and that there are no alternatives also in these areas currently present. So in what we will outline shortly, we will show why litigation is important, but we will also show why alternatives from within the local communities are important, and the first green sprouts that we're seeing in that respect in Lichtenburg and Tsubota municipality especially. Before I hand over to Tian to give you point you to the relevant sections of the Constitution that we will be relying on in these cases, and then give you a timeline, I'm just going to point to the largest strategy that Sakeliga is following here. We get asked sometimes why we do cases in Lichtenburg, or why we pick any particular court case or place to intervene and take hands with the local business community. And it is because there is precedent-setting capability in those areas. And that is why we're in Lichtenburg. It's an advanced case of state failure. The town has been in various states of collapse and dysfunction for several years now. And as this problem escalates, it makes it easier not only to litigate, but also to develop alternative solutions that can be implemented by the local community, driven even by the business community, without, shall I say, asking permission from the state first, just because of the dire situation there. But our intervention currently is focused on alternatives in these municipalities, either limiting the harm of state failure or forcing some reform where possible, but in cases where that isn't, to develop through litigation, recognition, and room for alternatives driven by the local community. An example of a previous phase of our strategy was our intervention in the Constitutional Court, ultimately with regard to electricity provision. You may recall that 3-4 years ago it was very prevalent for towns to be cut off completely by Eskom because the municipality has failed to pay over the money to Eskom. And what that, of course, means is that the town will completely collapse if we allow Eskom to use that extraction strategy. It's basically a debt recovery strategy. It's holding the townspeople, the paying business people in these towns hostage, and trying to extract money from the municipality in that way. The problem there is that it's two entities of state fighting with one another, and through our litigation in that phase, we were able to make it illegal for Eskom to cut off power to paying customers in this way, and that has led to billions of rands of saving in these towns, and has given us the breathing room, and towns across the country the time needed to implement further litigation and alternative strategies. Because, of course, we want Eskom to be paid, but we just can't allow Eskom to cut off electricity to the paying townspeople and the paying businesses in these towns simply because of state failure at another branch of the state. So that's an example of our largest strategy, where we develop through litigation the building blocks and limit the harms of illegal and irrational state activity, but then also develop and buy time for us and local communities and local business people especially to develop alternatives. Tian, I'm going to hand over to you, ask you to give us an overview of the relevant constitutional provisions, and then also a timeline of the case so far, because it's quite complex, runs over 2 years, and then thirdly, just give us a glimpse of what alternative structures are being developed in Lichtenburg and why that could be important for towns across the country.
Thank you, Pete. If we speak about interventions in municipalities, the overarching mechanism for that is Section 139 of the Constitution of South Africa. Now, there are about 25 municipalities in the country currently under various forms of administration. So that already tells you that this section of the Constitution wasn't designed to handle the levels of state decay that we see. But be that as it may, what we have in Section 139 is 3 forms of administration, really. And firstly, and that's what we see often, is we see a discretionary intervention in municipalities by the provincial executive, the relevant provincial executive of that municipality. So in the case of Ditsibotla and Naledi, that would be the Northwest Provincial Government. So what happens in Section 139(1) of the Constitution is when a municipality cannot fulfill an executive function in terms of the Constitution or legislation, the relevant provincial executive may intervene. So it's not a mandatory provision. There's a discretion to be exercised by the provincial executive. And we see that often, although provinces are, of course, for obvious reasons hesitant to intervene in these municipalities. But then we can take it a step further. There are conditions which, if present, provincial executive has to intervene. So then there's no choice left for them to do so. A provincial executive must intervene if a municipality cannot fulfill its financial obligations or cannot deliver basic services. Now that's definitely the case in many municipalities in Northwest, if not all of them. So when these conditions are present, the provincial government must intervene. They must impose a financial recovery plan. They may dissolve the municipal council if they don't want to work with the provincial executive to administer the province and to implement the plan. And they can also take other measures to assist with the administration. At this point already, National Treasury must get involved and assist with drawing up a financial recovery plan. So this is a multi-government sphere intervention already at this stage. But then one may ask, what happens when the province does not or cannot intervene? And that's when we turn to Section 139(7) of the Constitution, which basically determines that if a provincial executive cannot or does not intervene, the national executive must do so instead of the provincial executive. Now, there are about 3 municipalities in the country currently under national administration, and many municipalities under provincial administration, some of them from 2021 already, and with no prospect of success. So one might ask, why haven't these municipalities been placed under 139(7) national administration? And that's exactly the question Sakeliga is asking the court in the present matter that we'll be discussing today. And then one may also ask, but what if the national government is also unable to intervene successfully in a municipality? What if all else failed and Section 139 of the Constitution has been exhausted? Well, then there's a special power that the courts have in constitutional matters to craft any remedy that is just and equitable in the circumstances. And that's where many litigation in municipal matters will be turning to. Because if you exhaust 139(7), you need to ask the question to a court, well, what now? And then there are several options that can be crafted. And Sakeliga, we have proposed to the courts in our special master case to create such a remedy in the view of the fact that administration in those municipalities simply is not bearing any fruits. So let's turn to a timeline of two cases that Sakeliga has instituted in Northwest in respect of the Ditsobotla and Naledi municipalities. And we started in May 2021 with the so-called special master case. That's what it's known as, because we asked the court to craft a special remedy for us. But firstly, the basic prayer that we asked for the court is to place this Naledi and Ditsobotla municipalities under provincial administration. One would imagine that having reached such levels of decay, provincial administration would have ensued long ago. The fact of the matter is provincial administration has been tried in these municipalities a few times. Unfortunately, the Northwest government itself has been under administration various times. So that is why Sakeliga also asked the court that pending the proper implementation of a financial recovery plan, a so-called special master must be appointed in terms of Section 172 of the Constitution to oversee the administration of certain financial matters, such as the payment of Eskom. As Peter said earlier, we want Eskom to be paid, and the special master, the role of the special master is to see to the collection of monies for service delivery in a separate bank account, and that those Eskom and water boards can be paid directly from that separate ring-fenced bank account.
Tian, if I could add here, I think sometimes we work in Lichtenburg, or we go there, we see the collapse, and of course the people of business people of Lichtenburg and others in similar towns know this, but maybe not everybody knows this. When we say the municipality has collapsed, we mean that it's completely collapsed. In Lichtenburg, there's been at various times different people disputing who's mayor. So there's been times where there were two mayors in Ditsobotla. Then the sheriff has attached so many assets in the Ditsobotla municipality, including computers on which the administration is being done. The riots there by municipal staff and others have threatened the life of the administrators who've arrived there. His bodyguards have been beaten up. The paperwork of the municipal offices have been thrown into the streets and blown away by in the wind. When we say collapse, we mean collapse. We mean intermittent or no water supply to some areas. We mean regular power outages, failing infrastructure. And of course, it doesn't mean complete chaos, because the community, the business community there, manages to maintain control and order and some level of service delivery. But what is working in Lichtenburg is not working because of the Ditsobotla municipality. It's working because of people's propensity to keep providing order and making things work under difficult circumstances. So it's not. You can travel to Lichtenburg. It's not. We're not saying it's a war zone, but we're saying it's only working because of. It's only working in spite of state failure. And as you say, Lichtenburg and Ditsobotla and the municipalities there aren't failing on their own. It's also the province itself. So I just thought to highlight that when we say collapse, we mean the municipality has collapsed. The town maintains the ability to function, but of course, unless we create a craft litigation to support that in jurisprudence, that will over time be untenable, because there needs to be we need to find alternative ways of maintaining the town.
Yes, and Pete, you make an important point about the administrator having been obstructed to undertake his duties. And that is why Sakeliga is interested in a special master and why those communities in those towns are interested in a special master. Because a special master would typically be an external person or audit firm that cannot be subjected to the violence that a person sitting in the municipality could be subjected to. And so that it was one of the primary rationales for that remedy that we wanted the court to flesh out.
Tian, as you go to your next point, just to add more against on the special master again, our legal team developed this special master plea in the papers, and as Tian will point out, it's taken a certain course now, but we expect to revisit it. But it's something that the Constitutional Court has applied before, so we are applying principles developed in the Constitutional Court in other areas of state failure. Tian, you may refer to that later, but I just want to emphasize that this is, thankfully, we can work with existing jurisprudence here. It's not like we are asking the court to do something that it has not applied in other areas of complete state failure before.
Yes, correct. And that is exactly on the strength of the fact that special master has been applied in other cases as well by the Constitutional Court. We felt confident that we could ask for the same in Northwest in these dire circumstances. And just returning to our timeline, one thing that should be highlighted also when litigating in Northwest, and especially when you litigate against opponents that cannot even administrate the basic functions of a municipality, it's not very easy to litigate against such opponents. Because the same dysfunction also seeps into court proceedings and the way in which they litigate. So between August and December of 2021, Sakeliga has been dealing with the inadequate responses provided by these more than 10 state respondents in our special master case. Inadequate affidavits that don't conform to the court rules, that we had to bring an interlocutory application in court to compel these opponents to just deliver basic information in their affidavits. So this took a lot of time for Sakeliga to get through, just to get to a point where the case can become ripe for hearing. And then what also happened in November of 2021, while Sakeliga was fighting these interlocutory applications to compel adequate responses from our opponents, is that the Northwest Executive went and placed these municipalities in question, Ditsebotla and Naledi, under administration, like Sakeliga asked, but without informing us. They had a duty to inform Sakeliga because they are involved in a dispute about the administration of these municipalities. So they went in a clandestine way, and they put these municipalities under administration while still opposing the matter that Sakeliga was pursuing, asking them to put these municipalities under administration.
Tian, this is worth emphasizing. What the primary thing we ask of the court is that we say that it's illegal, and we ask an order from the court that the provincial executive must place this municipality under administration. Then the municipality opposes this. The minister of COCTA opposes this, and a host of state respondents all oppose this. Then, without telling the applicant, they do apply it, but they keep opposing this in court. But they've actually went and done this now. And to today, Tian will continue, but to today they are still opposing this, even though they have actually done what we've said that must be done. They are opposing an order of the court that it must be done.
Exactly, and as I'll mention a bit later, we only found out about this in September of last year, when they, in a very by-the-way fashion, informed Sakeliga of the fact that actually these municipalities have been placed under provincial administration. If we can just get the timeline back on the screen, then Sakeliga saw the dysfunction caused by these state opponents in this matter. Simply, we weren't making any progress because we had to not only fight the merits of the case, but we had to deal with all of these procedural issues caused by our opponents. So our attorneys approached the court and asked for the matter to be case managed. So that basically means that the judge president of the court can issue directives to all the parties as to when they must file their affidavits and to comply with the court rules when they don't. Typically, you have a solution like this when you have many parties in a matter, and especially when the parties have shown themselves not to comply with the court rules. So we went and asked for that in December of 2021. 6 months later, we had to go back, our attorneys, and ask again for the case to be case managed because no answer was forthcoming, unfortunately. And then only in August, we started getting responses from the court. But then as soon as that happened, one of the municipalities, Naledi, started to frustrate proceedings deliberately by objecting to an affidavit that Eskom has filed. And Eskom, and this is also worth highlighting, actually, although they were a respondent in the case, supports the relief that Sakeliga is seeking because they want to get paid. And Naledi objected to this, and they wanted Eskom's affidavit to be struck out because Eskom actually exposed a lot of the financial dire straits and inability to pay in the Naledi municipality, and the fact that Eskom has been going through a long process with that municipality to try and indulge them, to get them to pay, but with no results. So Naledi opposed Eskom's affidavit, and then eventually Sakeliga's attorneys forced Naledi to withdraw their opposition, only for Naledi to later to enroll this issue in September of 2022. Now, you can imagine that this causes a lot of delays to a case because there's now a dispute within a dispute that needs to be resolved. And then, as we all expected, in September 2022, Naledi's they were struck down, so they did not get the relief that they were seeking. And then just also, as I mentioned earlier, September 2022, Sakeliga found out for the first time that these municipalities have been put under administration.
So Tiaan, just to emphasize here, in terms of victory, we've won. We only realized we've won the case basically in September 2022, but it turns out we've won the case back in end of 2021 when Section 1395 of the Constitution was then called into play by the provincial executive, and they did apply provincial forced administration of the town. Now, we must just realize as we go through what Tiaan says now that there's no point where there's complete victory. We must all realize we're in a long haul strategy here, and we're going to see step by step ground being won by entities like Sakeliga and by role players in the town. And it's worth emphasizing that by forcing these parties to court, even though they oppose the case, it develops enough pressure for them to do certain steps, to take certain steps that allow us to, as Tiaan will point out, in cases that we have brought subsequently, ask for more from the court. And we intend to exhaust all of Section 139, and as Tiaan pointed out earlier, then ultimately propose to the court further solutions that it can develop in its discretion. So there was an important victory already in late 2021 that was only revealed in 2022. But Tiaan, please continue. But I just want to emphasize, step by step, we will make progress, and we have been making progress.
Correct. Yes. With these cases, a win does not always manifest in the form of a court order. It can happen before that, and that's what happened in this case. And it's common cause by this point that the reason that Naledi and Ditsibotla are under 139.5 administration is because of Sakeliga's case. Then, of course, notwithstanding this win, and also because of this win, Sakeliga proceeded in October of 2022 to take things to the next level, knowing at that point that we've achieved 139.5 provincial administration, and that it has failed because it's been ongoing at that point for more than a year. We approached the courts again, and this time with local business people and co-applicants, business organizations. We approached the courts again on an urgent basis. And this was partly provoked by the fact that at that point, water reticulation in Ditsibotla has completely collapsed. And by that, we mean that there was no water reticulation. The reservoirs were completely empty, and there was no prospect of any improvement. So Sakeliga approached the court in October on the same day. And just to clarify, from the outset, this application was split into two parts, Part A and B. Part A typically involves very urgent relief, and then we sought a court order pending the adjudication of Part B, which is a more structural approach, and also urgent, but not as urgent as Part A. So on the same day that we approached the court in October, we obtained a court order in our favor, ordering the municipality, the administrator of the municipality, to ensure the water supply of Ditsibotla municipality. So again, to clarify, the first application from 2021 was in respect of two municipalities, Naledi and Ditsibotla. This one pertained only to Ditsibotla. So we obtained a court order, the water supply must be ensured, and importantly also that Sakeliga and our supporters should be allowed to observe this process whereby the water would be restored to the residents. Now, as we expected, the municipal administrator did not succeed in restoring the water supply, and Sakeliga supporters and our and local business people in the town were also prohibited from observing the restoration of the water supply. So Sakeliga again had to approach the court. Just a few weeks after that, in November 2022, we approached the same court again on the same facts, and we pointed out to the court, or at least we wanted to point out to the court, that nothing is forthcoming. The water situation is not improved despite the court order. And it's something we'll highlight a bit later, but it's not always possible to, by way of court orders, to compel government to order them into better service delivery. It's not always possible, but nonetheless, we are working with a broader strategy, and also with a view of Part B, we approached the court again. And unfortunately, the hearing of the matter was postponed because of load shedding and lack of fuel for the court generator, and also because an answering affidavit was filed by the respondents a day before the hearing. And I have to emphasize that is highly irregular, even on an urgent basis. And also, the affidavit was signed before that. So it looked like a deliberate attempt by the respondents to have the matter delayed, which is what happened.
Tiaan, could I ask, is this the case where the opposing parties from the state arrived with legal team totaling about 18 representatives, with one of them wearing slippers?
Yes, Pete, indeed. That was that appearance. I counted about 18 legal representatives from the state, and one of them did appear in slippers. One of the many absurdities that we had to confront in the lackluster approach of the government in opposing this matter. So the case was postponed. Fortunately, our attorneys were able to obtain a court date just in a few weeks after that, again in November of 2022, when we had a virtual hearing, and unfortunately the matter was again postponed because the judge decided to refer the matter back to the judge who heard the Part A application in October. So obviously dismayed by this outcome, our attorneys pushed again for the date for the case to be heard soon, and with the court recess approaching, we only obtained a court date in March of 2023. So this is again irregular in a sense, because something, when you speak about urgency in legal matters, hardly anything can be as urgent as an entire community or multiple communities not having any water supply, children walking around with buckets in the streets not going to school, and apparently this case wasn't urgent enough to be heard even within 3 months of it being filed at court. Be that as it may, we went to court again in May 2023, and we had a special allocation for 2 days for the case to be heard, along with the special paymaster case we spoke about earlier. So the special allocation, it involved these 2 cases being heard together. And just to zoom out again a bit, we have to keep in mind the special master case. Sakeliga asked for 139.5 provincial administration, and in the subsequent case, the Tsibotla water case, we asked for 139.7 administration. So in a sense, the facts of the matter, we've achieved a victory in the first case. So the relief sought in the 2021 case became moot because the government implemented what we wanted. But still, there were some outstanding issues in the first case that had to be heard, and the cases were enrolled to be heard together on the 22nd of March in 2023. And again, Sakeliga, we went to court, and again, the matter was postponed, despite the fact that we had a special allocation. And again, the reasons were twofold. In the first instance, we were informed that there were many other matters on the court roll for that day, and the case would be crowded out. And in the second instance, again, Minister of Finance filed an affidavit in the case 2 years after it was filed. So he filed an affidavit in the special master case. So usually you file those, your answering affidavits. In the case of the minister, he filed an answering affidavit 2 years before that. So he had 2 years to file a supplementary answering affidavit, and he chose to do so just a few days before the hearing in March, the case already having been postponed twice. So again, the matter was postponed. At least we did obtain a court order strengthening the Part A order we obtained in October of the previous year, and the district municipality was also ordered to restore the supply of water in Tsibotla. So then, that was fortunately the last postponement. So we had 3 postponements in total. And the case is now enrolled for the 5th and 6th of October, which is this week. And we'll be heading to court on both matters to be heard, and hopefully to get a resolution on Part B of the Tsibotla water case. And just to reiterate, what we are seeking in Part B is that the municipality, Tsibotla, must be placed under mandatory national administration. So that means that the national executive must impose a financial recovery plan in Tsibotla, and also oversee the administering of various functions in the municipality, and they can dissolve the municipal council if they wish to do so, and in the final analysis, they must ensure that order retakes in the municipality and that the water supply is fixed. And we, for obvious reasons, we are not relying on those intended outcomes, which is why there are also alternative structures which Pete will refer to, which also are in place to hedge against a very likely possibility that 139.7 administration will not be successful.
Tian, this is relates to a question by John Endres. John, thanks for your question. John is the CEO of the Institute, the IRR. John asks, are there any studies on whether placing a municipality under administration improves outcomes? Does it help? And I'm asking my colleagues to place a link there, if we can, in the stream, to a list of administration at provincial and national level. It's on the Cooperative Governance and Traditional Affairs website. We'll share that if we can. But there you can see a list of how many municipalities are currently under some form of administration. And John, we're not aware of any studies who conclusively show this. And I suspect that that's one of those things. Do you need to do a study to show that the sum of the angles of a triangle or the corners are 180 degrees, or something else like that? It's because it's obvious, and we are not aware of any case where administration has successfully led to a successful turnaround. So administration, we know, is not the answer. And Tian, before I hand back to you, I'd just like the audience to recall, in the beginning, Tian explained that the constitutional provisions, section 139, provides for a discretionary provincial administration, then a mandatory provincial administration, and then a mandatory national administration. And while through our court proceedings, we are giving every opportunity to the local municipality, the district municipality, the provincial executive, and the national executive to turn things around. We're giving them ample opportunity. That's, in fact, if they start doing their job, then there's no need to proceed with the court case. But we are proceeding, and we are proceeding in the expectation that they will keep failing like they have, and that we will have to craft alternative remedies like the special master, and that is why we are developing these proposals and including them in our papers, and we expect things to progress to a state where, under supervision of the court, these alternatives will be implemented, or at least room will be created through the litigation and through the jurisprudence for alternative interventions at the initiative of business people and local communities. Tian, back to you.
Yes, Pete, and I'm going to try to put up that list of provincial interventions. If our producers can just pull that up for us. There we go. So we have about 22 municipalities under 139.5 administration currently, and you can see that many of them have been in ongoing administration for many years. So like the equivalent of administration in a commercial context is business rescue. So if you think about business rescue, typically you want your business rescue process of a company to be finalized within a few months, 3 months, 6 months, typically not more than a year, because that will point to the fact, if it goes beyond that, that your business rescue process has failed. The company will likely go into liquidation. On a municipal context, it's not much different actually. So administration is not something that should be applied perpetually. It's a once in a while, perhaps in some municipalities, you'll see, or that's at least the intention, to have some form of administration and to get the municipality back on track. Now, to have municipalities being administered externally from 2018, 5 years, going in and out of administration, only some of them going into national administration, points to the fact that this is not working. We are not aware of any successful administration that's been done by the province of a respective municipality or by the national government. So clearly, we need to look beyond that. And a solution in this respect, I don't think is going to be arriving soon, if ever. So we need to provide for other solutions.
Tian, all right, so ladies and gentlemen, let's just recap where we are. We've outlined the relevant constitutional possibilities here. We've covered a timeline of the case. As you've seen, there's been progress. Even though the opposing parties deny that progress, we have achieved through the pressure of the court cases important progress that's allowed us to escalate what we're asking from the court to Section 1397 now, and it's also allowing us to support the community there, the business community, in developing some alternative structures. Tian, are there anything else in the timeline of the litigation you'd like to cover? We're running into that case. Those hearings will take place on 5 and 6 October. That's tomorrow and the day after. Is there anything you'd like to add to the timeline? If not, I'd like to move to some of the green shoots for alternatives in the town.
The last thing I'll mention, which is important, is that we are heading to court this week. It's not to say that we will get an outcome or court order this week. We might only get one in a few months from now, or the case might get postponed. So we don't have clarity as to when we'll have this case finalized, but we are hoping to obtain a court order very soon and to finalize this matter once and for all.
Yeah, I'm afraid that the government and the opposing parties have succeeded in delaying the proceedings, and they can, but they cannot prevent us from developing, in the end, alternative solutions through a combination of jurisprudence and where we'll turn to now alternative structures. So, ladies and gentlemen, the court cannot order the impossible. Lex impossibilia non cogit lex, if my non-legal Latin allows me there. The court cannot force or order the impossible. And what we're seeing is something that points to an impossibility at the capability level of the various levels of the state, from local to national government, to execute a recovery. That means that the local community will start to intervene at their own initiative, and preferably within the scope developed by jurisprudence that just gives them security of knowing that they are able to do that and they are protected when they intervene in these ways. So a very important development in Ditsobotla is the founding of the Ditsobotla Services Association, the Ditsobotla Dienstevereniging. It's at the initiative of the local business people in the town. A combination of important parties in this is organizations like Agri Northwest, which has been from the get-go actually a leading entity in Northwest. Very important there to see something that I expect we will see all across the country, is that agricultural groups actually have both the emotional and level of investment and capital level of investment, the capabilities for that, and the commitment to stay in the area and make it work. So importantly, we're seeing agricultural groups working with business people in town to develop these alternatives. And the Ditsobotla Dienstevereniging, the Services Association, is a group that is founded as a non-profit that is currently working to set up systems, both on the accounting side and in the implementation side, to develop, to collect revenue on a voluntary basis from the businesses and residents of the town, and use that money to either negotiate with various levels of government and then release some of that money where it will be well spent, and if not, use that money to intervene and provide services and provide emergency relief as they see fit. And it's important to mention in this at this point, Tian and ladies and gentlemen, that this is not a tax revolt. We of course we understand that across the country, especially in collapsed municipalities, people would say, well, what's the use of paying my tax money. It's actually daylight robbery because it's just getting stolen and wasted, and nothing of it goes for the common good. What's different here in Ditsobotland, what's happening in other places across the country as well, is that no accounts are being delivered anymore. The municipality has lost the ability to invoice people across the town, to send them bills, to send them accounts, tell them this is what you owe us. The valuation rolls are outdated. Actually, it's becoming impossible for the town has lost the ability to collect revenue. So I don't know if this is a good thing or a bad thing. It's just the way it is that there's not a tax revolt going on in Ditsobotla. There's no collection anymore. Not at all, but to a large extent. The ability to collect has left that municipality. And this opens the door to initiatives like the Ditsobotla Dienstevereniging to then collect on a voluntary basis revenue that they will figure out a fair way that they think they can request from the participants and use that for the betterment of the town. Tiaan, have I given a good description there? I know it's early days, and there's of course no guarantee of success in any of this, but this is, we think, the direction things will have to progress for there to be recovery.
Yes, Pete, absolutely. And if we look at the courts that themselves are increasingly cynical about administration, I actually want to refer to a case of Gitlingrivier concerned citizens versus Gitlingrivier local municipality, also in Northwest, where the court remarked that it's becoming commonplace in South Africa for municipalities to disregard their constitutional duties and to fail service delivery, and to do so with impunity. And then the court remarked, and this one is really it's telling. The court said, sadly, the impunity extends to court orders. So the only alternative is associations like the Ditsobotla Services Association seeking to deliver services and to collect monies from willing participants. So this is also important to emphasize that before the Ditsobotla services delivery even got the ability to collect funds, residents were already lining up and asking, about 300 of them asking, how can we pay money into your bank account? Because they were so eager for this alternative structure to get off the ground. So things are looking really promising in that regard from what I've heard from our contacts in that area. Things are really looking promising, and service providers are being considered to deliver services to this town in desperate need of services.
Tiaan, as we proceed toward the end of our briefing today, let me turn to questions, and then we can end with some final remarks, final thoughts. Inge Jansen van Rensburg asks, what can a business do to support you? Inge, thanks for that question. You're welcome to join Sakeliga, support us with funding. We're a non-profit organization. We use all the revenue we have and plow it back into the organization for that simple purpose of scalable solutions to state failure. And the word scalable is important because it's not, as we're not involved in supporting the community in Lichtenburg because we want a solution for Lichtenburg only. People across South Africa, business people, investors, and other donors support Sakeliga so that we can develop scalable solutions. We through jurisprudence and through alternative structures. So we are very happy if you find, and it's within your means, to financially support us. If you want to do so in a significant way, you can either visit us, set up an appointment, or we can have a briefing where we detail some of the other strategies and what we actually do with your money. It's being well spent, and we are as dire as the situation in South Africa is. we're optimistic that there's at Sakeliga a team and a strategy that can make a difference. And thanks for everybody who's already supporting that financially. Also, if you cannot support us financially, or if you do, a second thing you can do is, if you have information that can help us better understand the situation, whether it's with regard to municipal failure, whether it's whistleblowing on some crooked deal, or you have some insight in competition law or anything else that's going wrong at a scale level in South Africa, let us know. If you have some inside info, some views you think we haven't taken into account, and that would enable us either to better litigate, or that would allow us to develop alternative solutions. In line with something like the Ditsobotla Dienstevereniging, but municipal failure is not the only thing in need of alternative structures and independent solutions. So thanks for that question, Inge. If you want to do so right now, just visit the website sakeliga.co.za, click on Fund Us, or Befonds Us in Afrikaans, Befonds Ons, and you're welcome to make a donation right now. It's all deductible. We're a non-profit, and it's eligible for 18A deduction. Then a further question here was by Anonymous. Are there any municipalities operating efficiently in South Africa that can be used as an example of what can be possible in terms of service delivery? Sure, there are towns where things are going well, and the so-called semigration to the more western parts of the country are an example of that. And so certainly not all towns in South Africa are collapsing. And also even within metros or towns where it's going not so well in one area, in another area there it could be going well. So we're not telling you that everything in South Africa is collapsing and so on, that nobody is achieving any success. There are well-run municipalities in the country, and of course we hope you either live in one of them or contribute to turning your municipality, your town, into such a flourishing environment. There's a saying that in Xhosa and Zulu, I think it's prevalent both there. It's an idiom. It's Imbila Yeswela Umsila Ngukuyalezela. It means the dassie has no tail because it asks somebody to go fetch the tail instead of going itself when the animals all got tails. In Afrikaans you'd say, I think, as jy iets gedoen wil hê, doen it self, or in English, if you want something done, do it yourself. And this is why I think we are optimistic about what's going on in Ditsobotla. It is because Sakeliga is not bringing the solutions to the town. We're working together with Agri Northwest and other groups in the town who've reached out to us and said, we'd like to help you, and we'd like you to help us develop a solution not only for Lichtenburg and Ditsobotla, but something that can scale and be used in other places. Things have progressed so badly in Ditsobotla that we think Ditsobotla is a good case study for developing jurisprudence and developing alternative solutions. But again, the key thing here is you'll have to do it yourself. You'll have to form a vehicle, even if it's a local chamber of commerce or some other entity in the town that has the support of the business community and the townspeople. Maybe there can be more than one such an organization. The point is, if you want to turn your town around, will need to come from you in the town, from the townspeople, from the business people themselves. And even though it's not clear where, how the road looks ahead, we know that road has to be taken. And even if there are setbacks along the way, delays, deliberate delays, even as we've seen in our litigation so far, we have to proceed down that road, because that is the only one that leads to flourishing local economies again. Tiaan, any further thoughts from you?
Yes, I just add to that, Pete, that we also see that even in the most flourishing towns in the country, that's also often where you have very active community participation. CIDs,
yes,
in flourishing municipalities that still contribute to their towns in ways that the municipality can't. And obviously, when basic needs have been met, some room opens to do nice things for your town. But I think the observation holds in cases of state failure, but also where there isn't necessarily failure, is there's active community participation, people taking responsibility for their needs to be met, not only by the government, but also by themselves. And then just with regards to if you are interested in turning around your town, don't start from scratch. Lessons have been learned by various organizations across the country, including by Sakeliga and chambers and organizations that are in our affiliation network, and reach out to us. And we might be able to provide you with some insights or some even documents that could kickstart your process of turning around your town. So don't start from scratch. There are people that have been working on this for very long with great insights that might be able to assist.
Ladies and gentlemen, thank you for joining this briefing. I think these cover the questions and covers the issue. I'd like to invite anybody who's interested in solving some of these problems, figuring it out and not inventing the wheel for themselves, consider reaching out to us at Sakeliga. We have events upcoming later in October, especially for chambers of commerce, ratepayers associations, other business organizations. So we're having a great networking event with some great speakers that can share lessons learned and best practices on recovering, on how to turn your town around so far. So reach out to us if you'd like an invitation to those events and any further questions. Once again, thank you to our partners and the people in Ditsobotla and the area there in Lichtenburg who have supported Sakeliga, who've made it possible to develop jurisprudence here, to proceed along a troubled path, but on the one that does get us in the end through the chaos to the solution. All the best. Until next time.